I am back again on my second series on the matter of commonages. The fact of this post is because there are many persons are not real clear on the entitlement to be registered as a commoner. Now the commonage is based on any lands held in common. You will not see any word in the Act of commonage land. You may see commonage, but it's lands held in common. And I'm going to attack the point of who is eligible. The Act Section 3 states a register of commoners shall be formed and held in the settlement in which any land is held in common. Lands held in common. A register of commoners shall be formed and kept in the lands, in the town or settlement in which any land is held in common. Now, that point taken is this book of commoners should be held by somebody who will be able to attend the meeting at every meeting. But let's read further. It says, such register shall be formed in the first instance by the commissioner. Now, why did they say the law says first instance? It means that the commissioner / administrator should be the person who placed the entitled commoner in the book. All of other names could only be added to that entitled commoner by someone acting under the authority of the commissioner / administrator. Now, this registration book is not the book for commoners. It's of commoners, and it's the government issue book to know who all is registered as a commoner in such lands. I'm going to move on to the direction. It shall be formed in the first instance by the commissioner, and in accordance with such rules that may be given to him by the minister, which rules the ministers in power to make an issue. That is the problem most people has with, well, it says every descendant. No, it didn't say that. The law only prescribed to the entitled commoner. That means the person who was in the settlement at the time the act come into operation, not when the act was made. That's the time of year they get it mixed up. The act came out in April 1896, but that's when it commenced. But when the act come into operation, these lands were being operated under other headings. For instance, in Exuma, the lands were called Lord Roll Estate. Not until the year 2004 that it was clarified that, hey, hold on, these lands are commonage or land are all commonage, lands held in common. From there on, they advise everyone to get the rules together. But that's for another, the rules are for another series. Right now we're on entitlement to be registered as a commoner. The entitlement reads as follows, that every person residing at the settlement adjacent to any lands held in common, who is in actual occupation of any portion of the land so held in common at the time of this act comes into operation shall be entitled to be registered as a commoner. I'm going to read that straight through to you. says, this book shall be formed and kept in the settlement where lands are held in common. Now, if the administrator office is in some town, that it can be held at the commission office. But this must be appear to each meeting, or someone representing the administrator must be at the meeting. He could send an office clerk to represent the administrator, because this book is the government's issued book under the authorization of the administrator. Now, here is what the law tells you how do you qualify. Says in section 6 that where a person, you ain't no commoner yet, where a person applies to the commissioner to be registered as a commoner, the commissioner shall consider the application and take evidence thereon. Now, the commissioner must take evidence. No one can vouch for you. The law says the commissioner must take evidence on those 3 points of, did you reside in the settlement? Were you in actual occupation of land when the act come into there? Those 3 evidence must be presented in the simple fact of your birth certificate, which is as follows. It would be your grandparents' birth certificate, which is mine, my father's birth certificate connecting my grandmother, and my birth certificate connecting me to my father. There you go with the evidence you need. Now, the other evidence is the administrator / commissioner must walk to that settlement and say, well, okay, you said your grandmother was residing in this settlement during such time. Give me the evidence. Well, on this birth certificate would show that she was born in Steventon, Exuma in 1879 and was of Steventon descent. The next thing the administrator needs to find evidence, where is this house or the remnant of the house where she resides that connects your father and then to you. Those are the evidence. No one needs to vouch for you. No one needs to write no affidavit for you. He must take evidence, not hearsay. So going forward on that, the evidence, once taken the evidence, then showing your ancestry. Let's go what the law says. The commissioner, under the rules the minister issued to the commissioner. What were those rules? Those rules were issued to the commissioner on this island on the 2nd of July, 2004, which says the eligibility to become a commoner was issued to the commissioner. What those rules are to don't go any further than the grandchildren. If you look in the act would show you at the last rules that was approved during that period, says what is an ancestral. And it reads as follows. Direct ancestry means a son, a daughter, a grandson, or a granddaughter to a residing ancestor. That's as far as the eligibility goes. Now there are persons, they would say, well, look, I'm married to somebody who is not a registered commoner. What happened to my things or my possession? That person is then registered as a inheritor, is eligible to inherit what a commoner, spouse, or adopted children could inherit. They will not be able to use land or land issued to them, because a commoner is a descendant of an ancestral person. Is not an adopted or married to. You must be a descendant of a person who was on that land at the time the act come into operation. When you start operating as lands held in common. Now, I'm going to clear up the point that the court made, that lands held in common were not made from the law. The law was made for lands held in common. And so many persons believe that, well, you are not a legal commonage because you don't have any rules. Well, the rules didn't make the commoners. The commoners make rules. It says the commoner in any tract of lands held in common may make rules. The rules do not make you a commonage. It's the commoners make rules. So all need to be shown that the government book of registry, there were lands held in common. And the court so ruled in July 2023 that they could not place a certain commonage as lands granted to 20 people or more. But they could identify that the lands were lands held in common by commoners. There's a difference because the law is made for two types of commonage. It says commonage is lands held in common to include lands which have been granted to 20 people or more. It is two types of lands held in common. One is possessory, occupational possessory, and the other is lands granted to 20 people or more. There is a land, two areas that were lands granted to 20 people or more, which were granted to 44 people. And that those lands have the same act. So having that act as person saying to the other person, you have no business to be here, that is an insult, because if lands were not granted to 20 people or more, you are only on possessory, that your ancestors were there and were given possessory usage, not ownership. You can only say that to someone if it becomes ownership. The court itself had ruled when they named in this area here, which says Kenneth Nixon, a non-commoner, gave direction and was in a meeting giving direction of a certain fact. The Chief Justice asked the attorney, are your teachers commoners? Or the preacher a commoner? The people you're doing business with, are they commoners? Well, if that's such a type of law that only a commoners are entitled to be in the commonage, then you cannot rent to another person other than commoners. But there is no such law. So you cannot pick who you could say, who could come in or take part in any sort of meetings or proceedings. The only thing that a commoner is given is to have interest in land. There is no other law buying any other person of passing through, taking part, or marrying another commoner. And that word by commoners is an insult to a person. What you doing here? You ain't business here. No one came to ask for land. The only thing bars you is you shall have no interest in lands held in common. Once this register is properly formed, as many persons never seen the inside of a commoner's book. In the first line is entitlement. Who is entitled? In that case, my grandmother goes in there. And it goes in there, her date of birth. Then it becomes me, a descendant of Messiah DeVoe. Then comes my voice. Then it comes which year it start operating as a commonage. Those who does not have a rule in place would go back to the record. And on the side of the act, you will see ELAO. And on the side of that, if there's no starting date, on the side of that act, what you would see on the side of that act, the very following 1974. 1974 would then go in that for the year that it came in place. And then what relationship? Grandson would go here. What's the status? Third generation. That's how this book is designed to complement the act. You don't just, all of the information must be tabled in that fashion. Now, once you are registered to become a commoner, I would read for them, I'm missing a part of that. The act says how you can be registered. It says to be registered any commoner. That's the part that person would say you're interfering with the commonage. No. Any commoner may object to any such application. I'll read that. Any commoner may object, may oppose any such application. I'm from Steventon, and I'm going to draw an illustration. I could say to the registering person of Roll Down or to the commissioner administrator, John Newton is not eligible to become a commoner of Roll Down. And so he will then ask for evidence. There is the application. That application reads as follows. It does not have any place for votes. It has evidence of who you are. Once you give evidence of who you are, and you want to oppose that application, there is an application, a governmental application, to oppose such commoner, granting you Section 6 on that application. That application of the commoners, you can oppose. And if you have the evidence against that person, now I want to bring to your attention, there are 6 people you have to show why he or she is not eligible. There are 6 persons you have to give evidence of, plus 1, the applicant himself. His father, the mother and father of the father, the mother and father of the mother and the mother, that's 6 persons. You got to say, based on these evidence, these are where these persons from. Then you have to attack the applicant. To say the applicant is not who he say he claimed to be. These are the things you have to present on this form, this opposing form. Once you are registered, you are given a card as follows. You will be given a card where you will be numbered under the status. You will be numbered. Every commoner of this book has a card with a number. This book, and this is the card of each register, signed by the administrator and stamped with a seal. every commoner would have received a commoner's card. That is to be eligible for registration into a lands held in common. It is normally referred to a commonage country in a democratic commonwealth. They can make their own rules, they govern their own usage of land. But that did not exempt them. Once they come outside of that perimeters of they ought to apply to every other rules as every other person. The rules, their soundings are only for within their boundary. Once they step out of the boundary, they need town planning approval, they need license approval, they need every other approval from any other utility company. They need an approval to do so. The last point on registration is a non-Bahamian register to be a commoner only has the right under registration. Being registered as a commoner of a non-Bahamian needs to comply first with the Foreign Person Landholding Act. And that act says in section 3 of the act, a Bahamian, a non-Bahamian, other than a permanent resident, a non-Bahamian acquired land or interest in land under the device or by inheritance who intends to acquire land must first apply to the proper agency, and that's the covenant. You cannot go into the commonage and say you're a citizen. Registering as a commoner only gives you interest in land, no other privilege. And commonage is a statutory body where only a Bahamian can take part in that statutory body. If anyone has any question, feel free to call 803-3242, and I'll be more than happy to answer any of your questions within the law.